court's conservative majority says race cannot be a factor in college admissions. Tony Thetford, an ABC7 legal analyst, is live with us to help us understand what this means. Good morning to you, Tony.
Good morning. How are you?
So the court is not ending affirmative action, but limiting it. So what exactly is the court telling colleges and universities to do?
Well, in some, although it has not been overturned, it is essentially limited to a point where it's untenable. The court will allow race to be used for purposes of things like an essay. Say if a particular applicant were to use their experience and include race as a part of their history, that is acceptable. But for a university to use race as a factor in its considerations, as a standalone factor in its considerations for admissions, has now been deemed unconstitutional and violative of the Equal Protection Clause of the Constitution.
So if you're a student applying to a college or university right now, what is the real impact here?
Well, I think that if you are a student of color and you're applying to a university, I think that one would still use the history of their race or their racial experience as a part of the application process, but they should be aware that that needs to be a part of any sort of essay or something like that. I think that would be the focus in terms of how one's history in terms of race would be used or should be used under this new ruling.
Well, even if they include that information, it will have no bearing on whether a university lets them in, right?
That is absolutely correct. And what is going to be interesting here is what lawsuits might follow because of an assumption that a student of color who applied and was not admitted, that they were discriminated against. And then on the flip side, of course, majority students who apply and they're excluded from a university will then, rely on this precedent to sort of pursue litigation against the rejecting university because they would assume potentially that any students of colors who were admitted based on their race as opposed to those other factors. The precedent in this case required that other factors, in addition to race, be used in analyzing whether or not a person would be admitted. That was a 2003 decision, the Bollinger decision, the Bruder decision rather, and we've lived with that since 2003. This goes obviously further beyond that, and that consideration of race now has to be excised from those considerations.
Tony Thetford, ABC7 legal analyst. Tony, we thank you so much for your insight, and of course we're standing by to hear President Biden's remarks on this. Thank you so much, Tony.
Watch breaking news on YouTube. Subscribe to ABC7 Chicago Eyewitness News.